Big Supreme Court win yesterday, 9-0.
Yep.
In a court that rarely does that now, do you see a 9-0 ruling on especially something that is highly political? And of course, the liberal news didn't exactly take it lightly.
Well, because you had some Republican conservative judges that said that Colorado was perfectly correct, that this was a slam dunk, and that includes people like Mike Ludig and others. And then you had the whole anti-Trump crowd that said, the Colorado was right. And then 9 justices of the Supreme Court said Colorado was wrong. But I want you to hear the reaction. Our team has put together, and I appreciate them doing this, what we call a supercut of reaction from everything from CNN to the University of Virginia to MSNBC and more. Take a listen.
We've learned that it was a 9-0 decision ruling that Donald Trump can be on the ballot in Colorado and other states.
I'm not confident that that will produce a result that's good for American democracy.
I had been concerned that should it go to the Supreme Court, they would rule this way.
I'd laugh if it weren't so sad.
My next guest says Donald Trump is still an oath-breaking insurrectionist. Do you have confidence in the Supreme Court? Do you think this court is partisan?
The court itself may have overstepped.
The court went way further than it needed to go.
Our colleague Melissa Murray has called this Supreme Court the YOLO court.
The criticism of the court is that they're playing interference.
Not since Bush v. Gore have we seen a court that's had this many opportunities to interfere in the election.
The headline here is that this is a unanimous ruling, but if you scratch the surface just a little.
This is a 5-4 ruling on part of it.
This is actually a 5-4 decision.
It's 5-4.
Trump will take this, spin it, spread the misinformation, disinformation on it. So it's a win for them.
He's on the ballot and voters will vote, and he looks like he's headed to become the Republican nominee for president.
You can't save a people from themselves. If they're determined to reelect him after he organized that insurrection, then there's nothing to stop the people from doing that.
First of all, there was no 5-4 decision. It was 9-0 on that. Colorado had no authority. States cannot create chaos. 9 justices of the Supreme Court. Kagan, Sotomayor, and Jackson wrote a concurring opinion, but they concurred in the judgment.
So explain what that means.
Okay, concurring opinion means we agree with the judgment. In other words, Colorado cannot, on their own, take somebody off the ballot. States don't have that authority. But they thought the court went a little bit too far as what they actually held as the rationale. But on the judgment, they concurred in judgment. So 9-0. What's ironic to me is the way the left has gone after Kagan, Sotomayor, and Jackson CC in particular, maybe.
Yeah, it is ridiculous. And what is so funny about this is what they don't understand is, let's go just to the logical conclusion of what they want the Supreme Court to rule. That, oh, yes, one state can take somebody off the ballot. They can make the determination. Well, would they have been so upset if it were Texas that had said, look, we're pulling Biden off the ballot. He's not able to run. They don't understand that this has far-reaching implications. This is just not about a pro-Trump decision. This was a our constitutional republic decision, and it was right, and the liberal justices got it right and should not be attacked because they actually made a right decision.
You know, the left, Andy, if they don't agree with the opinion, all of a sudden you're anti-democratic, you're anti-constitutionalist, and they're going after their own people.
Yeah, their own people become fodder for the mill of attack. I mean, Justice Jackson did the right thing. Justice Kagan, Sotomayor, they read the Constitution. They said that the states do not have the right to create a patchwork quilt of this is a candidate that can stand for a presidential election. This one cannot. We would have 50 different opinions as to who should be on the presidential ballot and to preserve uniformity. And Justice Kagan said this during oral argument. Isn't this a federal question? So she signaled that at the beginning. But you step away from the party line by the woke left and you're dead. Whether you're a conservative or a liberal, progressive, you are dead in their eyes and you need to go.
Joan Biskupik, who was a reporter for the Washington Post for years and now CNN commentator on the Supreme Court, saying this was a 5-4 decision. Now, where are they getting that from? Because it was 9-0 on the judgment. What was the judgment? The judgment was the Supreme Court said, all 9 of them, the states don't have the authority to do this. So they are making things up. That's what this is.
Absolutely. A per curiam decision is unanimous. Unanimous. It's not 5-4. It's 9-0. So it's absolutely just misinformation and false information that they're spreading.
So here's the real issue I think you got to get to. And this is I think a fundamental constitutional liberty issue. The court made the right decision. They've got another case that's up there right now, and it's a big one, and that's this presidential immunity. We're taking the view at the ACLJ that it's a limited presidential immunity for official acts, not this absolute immunity that they were talking about, some of Trump's lawyers were talking about. But when it's an official act, which I would assert that what he's been charged with were official acts, then you have to be immune, and that's coming off of a case called Nixon versus Fitzgerald, which allowed for civil immunity from litigation for official acts. But you've got all of this pending at the Supreme Court right now. Andy, if the reaction to this case, where most people knew we were going to win, I mean, I'm thrilled it was 9-0, but most people knew we were going to win, except for the Mike Ludigs of the world and some of our friends even. Some of the commentaries they're writing are so over the top. But now you got the immunity case. That's going to be that's a much closer case for the court.
It is going to be a closer case for the court, and I think it's got to be looked at very carefully. As you said, we're looking at saying that the president should be immune for official acts taken as president in her or his administration post-termination of their administration. In other words, a president should not be hampered by having to look behind his back every time he makes a decision for fear that he's going to be prosecuted because he's made a political or a policy decision or a presidential decision after he is terminated from office after his term expires. And this is a very subtle distinction that has to be made. And I think that the Supreme Court, I hope, will read the Constitution as we have read it in this Anderson case out of Colorado and do exactly what the Constitution says.
Here's my prediction. I'm not, this is always dangerous. I think what the court's going to do is, I think it probably is a 6-3 decision. Alan Dershowitz said that last night on Sean's program, and Jordan was on with him. It probably is a 6-3 decision. I think the court says the D.C. Circuit got it wrong, saying that immunity expired at 12:01 January 20th. That's absurd.
It is.
So that gets thrown out. Then they say it's limited immunity in the sense that it's limited to official acts. There was not really an adjudication of what was or was not an official act here, so it goes back to the district court for adjudication.
That's right. If they make a determination that the court has to decide whether there is some immunity and does it affect official acts, it may be remanded to the district judge to make a finding as to whether these were official acts during committed or acted upon during the scope of the presidency and thus subject to immunity.
And they even in the Nixon versus Fitzgerald case, they said it's even the outer periphery of those acts are covered. So I think that's what they're going to have to conclude. We'll see. It's going to be very hotly contested, though. Make no mistake about it. Briefing due March 19th, I think, or 20th. We've got to get our brief in. And then arguments not till the end of April. Decision probably the end of June, Logan.
All right, let's try to quickly take these couple calls. Let's go to Terry in Oklahoma, line 1. Terry, you're on the air. Quick.
Hi, gentlemen. First of all, I'd like to say thank you so much for the work that you do. I appreciate it. I was getting ready to donate to your website here, but I thought I'd call first. My question is, first of all, I worked for a state agency in Oklahoma for many, many years.
Yep.
And every office had a big placard that said, whistleblower law, you are protected.
Yes. Right.
You cannot be harassed, anything for making a claim.
That's
so
right.
Why aren't these gentlemen covered under that?
It's very interesting because they're covered you're under a state system, they're under the federal system. And there's a merit review board that's part of this. And then on top of that, and Andy, you've dealt with this, we both dealt with clearances before, they mess with their clearance. And that's how you freeze these guys out.
Yes.
You don't get rid of it, you suspend it.
Right. And it's a chilling effect that you put on these people by making their life miserable and marking them for future promotion and other jobs and other positions by scaring them into keeping their mouth shut.